you're a doctor or a nurse or a healthcare provider who's just been sued for malpractice, I'm sorry to hear it. I'm Jim Edwards and I'm a malpractice defense attorney, and even though I make my living defending people like you who get sued in malpractice cases, I'm sincerely sorry if you've just been sued. Let me tell you the 5 things you need to do right now if you've just been sued. Number 1, catch your breath, don't panic. It's not going to be nearly as bad as you think. If you got served with suit papers at 10 o'clock at night when you're walking out of the hospital after a long day and a long week, you do not have to panic over the weekend and be scrambling around making telephone calls and such. The next business day is fine. In my profession, we joke and say STAT means within the next 30 days. So this is something that can be dealt with in a reasonable fashion. So rule 1 is catch your breath. Rule 2 is notify your malpractice carrier. Now I know I just told you STAT means within the next 30 days and you can take your time doing things, but this is the exception to the rule. What you want to do is you want to notify your medical malpractice insurance company by the next business day. And this is something you should do yourself. I recommend you not delegate it. The malpractice insurance company is going to want to hear from you. And what you do is you get on the web and you locate your malpractice insurance company's website, and all of the big major national companies have them, and even the smaller one-state companies will have them as well. Locate the claims line, the telephone number for the claims line, or if you can't find one of those, the customer service line. You'll want to call them up, and you'll want to make a note of the date, time, and telephone number that you called and the person that you spoke with. Now that note is going to go into a separate file that you're going to create called legals. And you want to keep everything that involves your communication with the insurance company, with your lawyer, the lawyer retained by the insurance company, your personal counsel. You want to keep all of that separate from the medical records for the patient. You don't want a mistake to happen where your legal information gets turned over to the other side along with the medical records on the patient. And you'll notify the insurance carrier, and they're going to want to hear from you. Even if you don't remember the transaction that led to the lawsuit and you don't remember the patient, they're still going to want to ask you a few questions about what happened and what you recall and what you know so that they can get it set up. So the second thing to do, and you want to do this by the next business day after you get those papers, is notify your medical malpractice insurance company. Now the third thing you want to do is you want to secure the chart. If it's EMR, if your electronic medical records are the records that are pertinent to this lawsuit, you want to secure that and make sure nobody makes any additions, changes, or deletions from the chart. If it's an old paper chart, same thing. Secure the chart, lock it up in a drawer someplace where nobody makes any changes. And if it's a situation where you see the lawsuit and you hit your forehead and you say, gosh, I wanted to add that to the chart, don't. It's much easier for somebody like me, a defense attorney, to deal with a situation where you've left something out than if you put something in. I had a case, happily it wasn't my client, but 10 minutes, literally 10 minutes after the doctor was served with the suit papers, the audit trail shows he was in the electronic medical records making changes to the records. It just made him look like he was doctoring the records. So don't. We can deal with stuff that's left out much easier than we can deal with something that you've added in right after the lawsuit. The fourth thing you want to do is, well, I don't know a nice way to say this without losing the power of it. The fourth thing you want to do is shut up. By that I mean don't talk about the medicine, the medical facts of the case. Don't go chat up the other physicians who were involved in the patient's care. Don't get a curbside consult. Don't take the images down to your radiologist friend to have them look at it. The only people I want you talking to about the medical facts of the case at this point is folks at your insurance company and your defense attorney. Those conversations are privileged. Now, you can, and I encourage you to talk to whomever you want to talk to, whoever you trust and is close to you. You can talk about the fact that a lawsuit's been filed. It's a source of stress. It's going to make you worried, anxious, resentful, and angry, and all of those feelings are going to be new sources of stress. Yes, I know you deal with stress every day, important things dealing with your patients, but this is a new and different kind of stress. So you're going to want to find a way to deal with that, whatever works for you. Prayer, exercise, whatever works for you, you want to make a conscious effort to deal with the stress of this. And it's fine to talk with your spouse, your significant other, a friend, priest, rabbi, counselor, or your dog about the fact that there is a lawsuit. Just don't talk about the medical facts. So the fourth thing to do if you've just been sued is don't talk about the details of the case, and do talk about the fact that there is a case. Now, the fifth and last thing to do if you've just been sued is probably something that you won't need to do. That is, you may want to consider whether you need personal counsel. Now, personal counsel is different from the attorney who's retained for you by the insurance carrier. When you notify the insurance carrier that you've got a new lawsuit on your hands, it's going to go through their claims process, and they're going to assign a man or woman who's an experienced medical malpractice defense attorney to represent you, to handle the litigation, and to defend you in the case. Personal counsel is another lawyer unrelated to the insurance company who you select and you pay out of your own pocket. Now, most of the time, a decision about whether or not you want the luxury of personal counsel is something that you can defer until much later. But in one case, you would have to think about it right now if you've just been sued, and that's the situation where, if either intentionally or unintentionally, you do not have medical malpractice insurance. Now, I know it's rare, and you're probably thinking, gosh, that's unheard of, but it's not. There are 3 cases in my firm right now where 2 doctors and 1 hospital did not have medical malpractice insurance. In 2 of those cases, that was because of an accident. Somebody dropped the ball. In one of those cases, the doctor thought he could go naked. He could be uninsured. And now he's learned that it's impossible to do that. If you don't have insurance with a medical malpractice insurance company, you're self-insured. And so if you don't have insurance, you're going to have to get a lawyer to represent you, and you're going to have to do that very promptly, because that lawyer has to file papers with the court that constitute your, quote, appearance, end quote, at the court. If that doesn't happen, if a document called a defendant's response or a defendant's original answer is not filed with the court, then the other side can get a default judgment against you. And a default judgment is just as valid as any other judgment after a full-scale jury trial. So if you don't have medical malpractice insurance, that's the 5th thing you have to do right now, and that is make a decision about who's going to be your personal counsel. So the 5 things you need to do are: 1, catch your breath; 2, notify your insurance carrier; 3, secure the records; 4, don't talk about the facts of the medicine in the case; and 5, if you don't have medical malpractice insurance, then you're going to need to line up a personal counsel to represent you. If this has been helpful to you, please return the favor and click the like and follow button and subscribe to this channel. We won't fill up your inbox, but we'll let you know when there's new content up so you can learn more about medical malpractice law and the litigation process. Now, turn this off and go notify your medical malpractice insurance company.